Oh, there we go. Okay. Hey, guys. So I am attorney Candice Colucci with the Colucci Law Group and also as a shareholder with Daly and Black. And so, as I'm sure most of you guys are probably pretty much aware, our law firm specializes in property damage insurance claims. So we are the people that represent the insureds against the insurance company to make sure that they are fully paid, and we work with public adjusters and contractors all over the country. So I'm also a trial litigator. That is what I specialize in, is trial litigation. So today, we are going to be talking about deposition testimony. And so we realize that's probably one of those areas that a lot of PAs have never had to deal with, contractors have never had to deal with. So when you get in this industry and you start working with these insurance claims, it's more likely that there's a potential opportunity that you're going to probably have to testify. So has anybody in this room had to testify in a deposition? Raise your hand. Okay, good, good. Has anybody never had to testify? Okay. Yeah, there are some people who haven't. Yeah. Well, we have a nice little crash course in what that looks like. So testifying is an art, not a science. It requires practice, preparation, and the ability to think on your feet. So where I came from with Stetson trial team, that is what I literally was learning how to do, is how do we run a trial from beginning to end, and how do we prepare for it? So we've done a lot of research and work on specifically a deposition. What is the meaning of it? What can happen? What can go wrong? What can go right? What are the goals of it? So it's important when you're on the other side, the one who's being asked the questions, that you know how to prepare for it and what could potentially take place. So the very first thing that happens is a subpoena. A subpoena is what is going to be bringing you to that deposition. It is important that you understand how subpoenas work and what that actually means. There are subpoenas for documents, and there are subpoenas just for you to appear. And so you want to make sure whatever you're getting from the attorney on the other side, because that's who's usually going to subpoena you, you're going to make sure you're reading it all the way through. It's going to be a legal document. It's going to tell you what your obligations are, what you have to do. And most of the time, they're asking you to produce documents, but they're also usually asking you to appear for the deposition. It's called a subpoena ducis tecum. It is a subpoena that's asking for documents. Has anybody in this room ever gotten one of those? Okay, so that's a lot fewer. 1, 2, 3, 4. Okay, 4 people have gotten a subpoena ducis tecum. Who raised their hand over here? Okay, what did you do when you got the subpoena? Called him. This is your person? Right there. It's your person. It's okay. Yeah. I know you're quick to justify that. I got.
We were just consulting on a project.
Okay.
So I called him to see if he also received it.
Okay.
And we called an attorney to see what she did.
What attorney did you call? So you called the attorney who was representing the insureds, and you were the consultants? Oh, you called a personal attorney. Okay. And then did you ever call the attorney for the insureds?
I never spoke with them on the
Okay.
phone, but I did via email, and I just provided them what I had, and I never heard from them.
So then you answered the subpoena because it had a bunch of questions of exactly what documents they wanted, and you went ahead and complied and gave those documents over.
Well, the one thing too, like everything that they were requesting.
Yep.
Already been sent, like, the whole report had all the information in it. They were just asking again because the insurance never provided it to me.
Okay. So when you get the subpoena ducis tecum, you need to understand what the subpoena is asking you for. The issue with the subpoena ducis tecum is that if you don't comply with it, you can be sanctioned by a court. And we were talking about the insurance companies are watching everything that everyone's doing. They're going to find any way to financially pretty much punish you. So this is a great area where people are ignoring subpoenas for documents that could be potentially sanctionable if you don't produce the documents. Question?
By the date I received it.
Yep.
They were requesting it from like 3 months prior.
Okay.
If there's anything that's typo or anything like that, does that,
Absolutely.
can I ignore it then?
not ignore. You can never ignore it.
Okay, well, I ignored it, that's why
I ignored it. The information was wrong. You're not the insurance company, are you? Right? So if that instance happens, which it does, you may get a subpoena that says, hey, you need to produce those documents on this day and time at this place. It'll say that sometimes, or you need to send them. And if you get it and you're already past the deadline, it just happens sometimes. Obviously, you guys have seen that. Put everything in writing. You're going to email that attorney and say, hey, I did receive this subpoena, just to let you know, is that it says I have 30 days to produce these documents, yet the date you're asking that it's due, it's literally a week from now. So please allow me 30 more additional days. It's the same thing we kind of tell people about any insurance claim. If you're getting something with a deadline and you can't comply to it, you don't ignore it. You respond back to them, letting them know the reason why you can't comply with it in that amount of time, and I need additional 30 days. Literally, that's what you're asking for. Gathering the documents. You need to consult an attorney. Let me tell you why. There is a difference between lay witnesses and expert witnesses. And you don't know what you are unless you have talked to the attorney whose case that you potentially going to be a witness for. So everybody who's potentially done public adjusting or contractors, you're like, I'm an expert. All right, that's one thing. But for the purposes of an actual case in a court of law, there's a designation between someone being a lay witness and someone being an actual certified trial expert for that case. So you can be an expert in your head because you've done a lot of construction, but you could technically you're only going to be a lay witness for that case. You're not going to be an expert witness. So the attorney whose case it is, you want to make sure you let them know that you got a subpoena. And say, hey, I got a subpoena. I wanted to know, what am I being subpoenaed for? Am I being subpoenaed for an expert or a lay witness? They will guide you and tell you what all of that means, because there is a very big difference on what you're going to potentially produce, what you're going to say, based on that designation. And that designation of you being one or the other is going to come from the attorney who named you in that case, who named you as that expert. That attorney as that person. That attorney is going to be the one who's going to guide you. A lot of people will, you want to make sure you reach out to that attorney whose case it is, letting them know that you've received it. And then two is, there are a lot of times that PAs and contractors have in-house counsel. Make sure they have your subpoena also, that they know. Objections to requests for documents. The reason why you want to talk to an attorney, the attorney who potentially has brought you in and potentially your own attorney, is that you have an opportunity to potentially object to some of those document requests. Or the attorney whose case it is can object, but also your own attorney can actually object. If we remember what the insurance company's job is to really try to find as much information they can to potentially not do what they're supposed to do. That's unfortunately what they do. So there are sometimes that there's documents in your possession that could potentially be protected that don't have to be disclosed. And a lot of times when they're sending these subpoenas, it's a great way for them to try to get documents that they're not really entitled to through you, that we now haven't given them, that now they're asking you. So that's why it's really good to make sure you're talking to those attorneys, that you're not just doing this blindly and doing it on your own. Talk to the attorney whose case it is, and potentially your own counsel. But here are some of those objections. To relevance, it's unduly burdensome, overly broad, it's vague, it's ambiguous. There's an attorney-client privilege, work product doctrine. Gives you an idea. Sometimes people they'll get a subpoena that says, I need any and all communications that you've had. Well, any and all, if you're an attorney who litigates, any and all is usually very objectionable. It's not reasonable in time and scope. So we won't just produce anything, we'll object to those things. Preparing for the deposition. You have to understand the claim. You need to understand what you're there for, why you're being called, which is why you want to talk to that attorney, and making sure that you're gathering all of the evidence and you're preparing of what you potentially are going to expect, which is why you want to make sure you're talking to the attorney whose case you're literally going to be going there for. General types of questions that you should potentially see. What will happen when you get to the actual deposition? They're going to start with the personal background. They're going to start with you. Who are you? What have you done? What have you been a part of? What are your qualifications? Do you have any certifications? Do you have any licenses? Have you ever been in trouble? They're going to ask you questions if you've ever been convicted of a felony. They have to ask you that. They're going to ask you if you've ever been convicted of any crimes of dishonesty. Those are going to be even misdemeanors, theft, misdemeanor, any of those bad check writings, any of those things. Those are things that you have to give them and let them know about. They're going to talk to you about the claim background. Some of the things they're going to ask you is, how did you get involved in this case? Who did you talk to? What did they give you to review? How did the whole entire process kind of evolve? How did you get to this place now that you're here in this case to testify for this? Your facts and opinions. I can't stress enough, which is why I always say from the very beginning when I'm talking to public adjusters or contractors, I'm saying, listen, from the very minute you get involved in this case, you should think it's going to go to litigation. And as an attorney, my job is really to go, these are all the things that could go wrong once we get in litigation. How do we make sure you're prepared for those from the very beginning? So your mindset should really be, in case this goes all the way to a trial, can I stand behind everything I have said, every email I have sent, everything I have demanded, and every line item in that estimate? I can't stress that enough. Because what people don't realize about trial litigation is that everybody knows there's going to be two experts. There's going to be an engineer who says no, an engineer that says yes. There's going to be a PA that says this, and there's going to be an adjuster from the insurance company that's going to say this, right? What a jury has to weigh is your credibility. That is what it comes down to. How qualified are you to make that opinion? And how credible you are. How credible you are. Which is why a deposition is so important and people don't understand that, is because your credibility starts at that first deposition. If you say anything during that deposition that is not true, it will come back to haunt you if it potentially goes to trial. Because their job is going to be to try to find those inconsistencies of what you've said and produce them to the jury. And a jury of your peers is literally something you most of the time don't want to have to even be in front of, because they're very sensitive. If they think you've lied about anything, you've lied about everything. So that's why it's so important you're preparing for a deposition with all the documentation and that you can stand behind everything. So sometimes I get these estimates and I get things like that, then I'm like, I see line items in it and I was just like, and they're like, oh, well, I didn't mean that, or oh, I didn't mean to include that. Oh, those little oops can jeopardize your entire estimate. Not just for the entire process, because the adjusters are seeing it and now they're thinking that you've fluffed the whole entire thing, we don't really need to pay it, all of these things, but it continues to haunt you through the entire case. Because that's what we're standing behind. That first estimate that you're sending them, that's what you're standing behind. And I've seen situations where a lot of times an estimate will be submitted and it's not complete and it's missing things and they're not writing language in that says, hey, this estimate's incomplete or any of those kind of things. And they're like, well, I'll just send another one later on. Well, now you've contradicted yourself. Unless there's a reason for why your estimate changed. It can't just because you were half-assing and you were in a hurry and you went ahead and submitted it. What is the reason why it changed? If there's not a justification for it at all, you've technically contradicted yourself. So being really clean and clear from the very beginning is important, but making sure you're prepared for the deposition for those questions that are going to come based on that estimate that you sent then. Because you can't fix it later on, because that gets used against you. So you want to make sure when you're presenting something from the very beginning that it's authentic, that you can stand behind it, and you're prepared to go line after line. I tell everybody that. Be ready for each line. So the basis for your opinion, if you're, and this a whole nother, take a long time to go over what it would be if you're an actual expert in a case and what that looks like, but you need to be prepared to give the basis for an opinion if you're going to make it. Why did you include that area of damage, that scope? Why did you believe that it was part of that loss? What was your reasoning for that? So that's always the question you should say in your head. If you're going line by line in your estimate, be prepared for the question to be line by line. What is your basis for that? Why do you need those mini nails? Why does it need hurricane clips? Is it code? Is it installation guidelines? What is the reason for it? You've got to be prepared for that. I have seen Really great. Some of my favorite estimates that take a really long time to do are estimates where in literally Xactimate, there is an explanation almost under every single line. Beautiful. Does it happen all the time? It doesn't. But those things you want to be prepared about. So if you're about to go to a deposition, if you didn't spend the time before making that line item estimate that has a great, explanation of exactly where it came from, if you didn't do it then, make sure you have it ready for the deposition. Because that's literally the areas and how distinct they should go down. And if your answer is, Xactimate just told me that I was there, that's not going to be an answer that's going to be justifiable. So you want to also know, what have you relied upon? So if you are a PA or a contractor and you've written an estimate and it's based on somebody else's report, you want to make sure you have that information, you know where it came from. So if you've written let's say you've written a mitigation, a water mitigation, or a mold mitigation, and it came from the mold report that gave you that protocol, you need to make sure you've got that information and you're bringing it to the deposition, and that you know what have you relied upon in order to create whatever it is that you've created, which sometimes comes from testimony. The question may have been, why'd you include the windows? What was your reasoning for the windows? Well, if you didn't get an engineer out there to do the windows, it may just be completely from the testimony of the insureds. I use that all the time. Testimony of the insureds. They weren't fogged before, they're fogged now, they're all having a hard time opening and closing, and they're all leaking. And that's why I included all those ones on there. And they can go all the way to the thing of asking you every single window. And if it was because if you're in an area where you said, well, it was a 25%, just be prepared to answer all of those line items for why everything's in there, not just because. If there's any videos or photos that you have relied upon, you want to make sure you're producing them to the other side, and you're going to make sure if you don't produce them that you're bringing them to the deposition so that you know, these are the other things that I have relied upon. Here are my photos of what I've relied upon. Don't just assume that the attorney has done it all. You're responsible for what you're going to look like when you show up. So even though you may have said, well, I've given them to the attorney and they should have all been produced, I've heard it a bunch of different times. But what people don't forget is you are now under a subpoena, a court-ordered document to appear with the documents, and your failure to do that could be sanctionable. And the answer that the attorney should have brought it is usually not sufficient enough. The other thing you have to be prepared for is they're going to ask you about money. What is the agreement that you have with the insured or the attorney? How much you're getting paid? How often do you testify for this attorney or this law firm or any of those kind of things? How often do you work on the insured side? Those are some of the kind of the questions that they're going to be asking you. One of the things that we hear a lot about, a question I see going back and forth all the time, is about fees. About getting paid for you to produce the documents and for you getting paid to testify. Every state is a little bit different on how they handle that. Oops, look at that. A podium. Look, Derek was like, do you need a podium? I was like, I don't need a podium. I was like, I'll just put my drink on the floor. He's like, well, don't knock it over. Yeah, thanks, Derek. So about testifying. So every state's a little bit different how they handle it. There are states that will allow you to get your travel time and your testifying time, and there's a lot of states where there's a fight about if a PA is on a file, can he also get compensated for testifying in the case and all of those things. There's a bunch of different laws that kind of surround that. In that instance, talk to the attorney who you're testifying for. Talk to that attorney and see what that means. Because here's what I can tell you, almost every state is of the same opinion, is that you cannot just decide to not come to the deposition because you haven't been paid. That is things that I have heard. And I'm all about everybody making money for their time. But what you never want to do is have your money stand in the way of an insured getting indemnified. That's number one, just morally wise. But number two is, literally most judges will say that your failure to appear just because people are fighting over who's going to pay you, you have been subpoenaed now by a court order to come and appear, and it can be fought about later on. Because there's a lot of time there is a fight of who actually is going to pay you. Does the plaintiff side pay you or the defense side pay you? Does the plaintiff side pay you and the defense pays back the plaintiff? So make sure, I've seen a lot of conversations about that where people are like, whoa, I sent them a massive bill and they haven't paid it, so I haven't produced the documents. Don't do any of that. Send them a bill, produce the documents. You want to be in accordance with what you've been subpoenaed, because you don't want to have to face a judge and say, well, I didn't get paid. And so I just didn't come and I didn't produce any of that stuff, even though I'm trying to help the insureds. You don't want to look that way. Okay, so we're going to show you a video. I think they're going to get it queued up now. So now we're talking about how to behave during the deposition. So I've got a little video that I'm going to show you in regards to what took place during a deposition in another case.
Next, we go back into the court cam archives, where tempers ran hot at one very tense deposition. This is Jack Garrett, former chemist for Monsanto, St. Louis-based industrial chemical company, being sued by more than 1,700 people in Harris County, Texas. The neighbors are claiming they suffered severe health problems as a result of living near a toxic waste dump site once used by the company to discard hazardous materials. Garrett's here today for a deposition.
When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
So far, so good. But that's about to change.
Was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
Interrupting is attorney Edward Karstoffan, who doesn't represent Garrett, but represents Monsanto, the company.
After you left Texas City.
Wait a minute, let me ask a question here.
Yeah.
Do you represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know, do you represent the guy or not? If you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Karstoffan has heard Tucker's suggestion and offers a suggestion of his own.
Why don't you keep your mouth shut? I'll do what I want.
No, you're not
No,
doing
Dad.
what you want.
No
I'll
way.
do what I want.
No, you're not.
No, you're not.
Yeah, I am.
That's bull.
Whatever objections I want to make, and I'll make them as loud as I want to make them. Now you just shut your mouth and we'll keep the record straight.
Don't tell me to shut my mouth, boy. Don't make me big, but you want to see how bad you are? Come on.
And I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
No, I want to know who's fighting. We're going to be outnumbered, Ed.
I'm going to tell you something else. You don't run this deposition. You
To
understand?
you, Joe.
You watch and see. You watch and see who does. Big boy.
I'm telling you, Joe.
Oh, you ain't telling me a thing.
No,
But don't be telling another lawyer to shut up.
Don't be
That
telling
ain't your
me.
job,
That's
fat
not your
boy.
job. Mr.
Now get back.
Peace. Don't be
That
telling
ain't your
me.
job,
That's not
fat
your
boy.
job. Mr.
Get back.
Peace.
This deposition, with lawyers making big bucks by the hour, has officially devolved into an exchange of childish insults.
I said before, you have an incipient bad
What do you want to do about it?
Well, I'd like to knock you on your
Wait a
head.
minute.
Come try it.
I'm gonna do that.
Come over here and try it, you
Wait a minute.
dumb son of a.
Wait just a second.
Well, I'd like to knock you on your
Wait a
head.
minute.
Come try it.
I'm gonna do that.
Come over here and try it, you
Wait a minute.
dumb son of a.
Wait just a second.
Come over here.
Hold it. Hey, wait a minute.
Get
Hold on.
close.
No way.
Get
Hold
close.
on. Hold on.
Thankfully, the two men never came to blows. But after the insults stopped flying, it was Jamail who ultimately landed the knockout punch. Monsanto Company settled the lawsuit and agreed to pay out $39 million to the plaintiffs. Thanks for being a fan of Court Cam. Subscribe to A&E to never...
Okay, so that gives you a good picture of how wrong a deposition can go. And it actually can happen. It definitely does happen more than we would care to admit in our industry, especially with what we're doing that is really passionate for us. So as an attorney, but also as advocates, you are insanely passionate about what's happened. I mean, you may be dealing with a home where I've had plaintiffs where they've died because of the mold that had grown in that house. The COPD got so bad. So when I'm taking a case like that we've been litigating it and we're in on a deposition and their plan is, make no mistake, if they're there for the deposition, their plan is to potentially find a way out of pain. That's what they're trying to do. But the other thing that they love to do is to find a way to enrage the witness. That is an actual goal. I have seen defense attorneys who have literally trained attorneys that way of how can we enrage the plaintiff, how can we enrage the advocates, how can we enrage the contractor and the expert. So in a situation like that took place, so they're interviewing, they're deposing that expert. One of the very first things that you'll see right there is that there were objections being made, which is why sometimes if a PA or a contractor will bring their own attorney, because you're actually appearing there and you're not represented by the attorney for the insured. So in most districts, we can't object for you. So a lot of times, if you're actually going to sit for a deposition, you'll bring your own attorney and allow them to be able to object for you. You cannot object for yourself. Happens a lot. People try it all the time because they watch it on a show, but you can't. So that's one of the things you have to be really aware of, is that if you feel like it's something that you need, you can bring your own attorney to it. And that was really what you were seeing there kind of at that beginning. But it also is so important as a witness to stay calm, cool, and collected. It is difficult. I understand it. They're going to insult your intelligence. They are going to accuse you and the insured on working together to create the biggest fraud. They're going to make sure that you know that you're the reason why insurance rates are going up and people can't afford to insure their house. That is not the place to argue those things. And they're going to try to take you down that rabbit hole to get you away from what you're actually trying to do. So the goal during that time is to really stay insanely calm and redirect and go, you know what? Was there a question there? Was there a question? Because you should only be answering questions that have been asked to you directly. And I have had instances where I have literally seen insurance companies ask things that are highly irrelevant, that are only in the only purpose of it is to enrage my witness. And my job as an attorney is to now step in to make the other attorney behave. It's not the witness's responsibility. And I know you want to. And I've got some of my girls in the back looking at me on the side eye because they're nice and aggressive like I am. But as a witness, you don't ever want to be that way. Because what happens to that video is that video can be admissible during the trial. And people don't think about that. So everything you're doing, well, it's being recorded, being videoed, you are sitting there in a position to advocate for this insured. And if you now go off and start a fight, that can now get used against you, be brought into trial in certain circumstances, and then now you're being harmful to the insured. That's what can happen with it. Being respectful, avoid arguing. You want to talk to them as if they are your friend. I have seen and I've prepared people and I have thought that they were ready to go. And I'm like, listen, go in there. This is your friend. Try to find a way to make it seem friendly. Start by saying, how are you doing? How's your day? Like, are you having a good day? Talk about something. It will lighten the mood for it. Don't go in there like, oh, I just watched a bunch of episodes of Law and Order and I am ready to rock and roll. Like, that attitude's gonna get you nowhere. It's gonna get me on 2 days back-to-back of depositions where he's like, well, what'd you take in third grade? I mean, they'll just ask you anything to drag it out, and then they'll fight with you with every single thing. You want that person to be your friend. Are they your friend? Make no mistake, they are not your friend. They are not your friend. And I know there's a bunch of other attorneys in this room. I haven't really truly, it's once in a blue moon it happens, but there's never a deposition or an examination under oath or a recorded statement that is taken with the plan to figure out how are we going to find coverage. That's not the plan for it. The plan is, how are we going to figure out a way to get out of this based on the questions that we're asking to potentially manipulate the facts in order to not have to pay. And that's just the truth of it. So that's really their goal when they're sitting you down. And that's a frustrating thing to take into consideration. And then also listen to where I tell you that talk to them like you're your friend. You're not there to argue with them. You're not there to make them see it your way. You're there because you're under an obligation and you want to answer the questions to the best of your ability, but not to fight with them. More tips. I tell everybody less is more, less is more, less is more. When I go into deposition, I tell them again, what is our sentence? They're like, less is more, okay? I'm like, that is a huge thing to understand. You want to answer the question that has been asked and nothing more, nothing more. So when they ask a question, give it a second. I always say repeat the question in your mind and answer what exactly is being asked. So if the question to you is, do you know what time it is? Think of it. That is a yes or a no question. It's not, yes, it's this. Yes, I think it's this. No, I'm not really sure. I didn't really bring my wash today. Like any of those things. It's very straight to the point, giving yourself a second and allowing yourself to answer only the question that has been asked. Do not speculate. A lot of times, what I see a witness trying to do is they're trying to present their case during this deposition. They want to make sure they're being understood, and they start now rambling on and on because they think they know what questions should have been asked, or they're like, well, did you really mean, I had a witness where I was like, don't speculate, don't go above and beyond, and literally this is what I heard out of his mouth. He goes, oh, did you really mean to ask me? And then he starts rumbling another question, and then he answers the question that he just asked himself. And I'm just like, what's going on? What's going on? He goes, well, I think she was confused. I go, well, you should let her be confused. Let her just live in that confusion right now. I don't need you to clarify it for her. He's like, well, were you wondering if the insureds knew about this? Is that what you're wondering? Well, let me tell you what I know. So that is a hard thing because you want to be thorough, right? We've been thorough for the entire process. If you're building, you're thorough. If you're a PA, you put your file together, you've done a great job, and you're like, this is my moment. I'm going to make sure they know everything. That's not your moment. We'll build your moment on direct examination during the trial. It's not there. So even if it's not making sense and the question they've asked is missing pieces, don't correct them. Don't need to do that. We as the attorneys for the insureds are going to make sure that everything is presented in the way. You don't have to worry about that. So just answer the question that's being asked. Answering questions beyond one's area of expertise, always be really careful about that. If they're asking you something else about something else, mold, if all of a sudden they're just like, well, how many mold spores were there and what is that? And you're like, well, you've done it enough. You're like, well, I know this is what this means. If you're not an expert in there, you say, you know what? There's an expert who specializes in that. That's the report that I got. That's the report that I relied upon. I'm not going to testify as to what they did or didn't do or what that means. I just know that's what I got and that's what I relied upon in order to create the scope. Embrace the silence. One of the tactics that I learned when I was in school, and I've used it a bunch of times, is to pretend like I don't know what next question I'm gonna ask, or to stop fumbling through my paperwork, because people get nervous in silence, and then they wanna fill it, and they just start rambling on and on. So I tell my witnesses, embrace the silence, which means if the question was, do you know what time it is? And you said, yes, just sit there. Complete silence, for however long it takes. Because most people are like, well, and it's 3:00, but did you want to know what time the accident happened? Well, I had asked the insured, but the insured wasn't really sure. But is that what you wanted to know? And literally the attorney's like looking, going, sure, go ahead. So don't say a word until the next question comes to you. Embracing the silence is one of the biggest things you really have to think about. Objections during the deposition. So there are few limited deposition objections that we're allowed to make as attorneys. I see this a lot because of those great shows people watch, and I'll see a witness being asked a question and they're like, that's irrelevant. I'm not gonna answer that question. You can't do that. And the way depositions work is that one of the objections we're never really ever supposed to make is relevance, because discovery is supposed to be an opportunity to figure out how to find admissible evidence. So when they're doing a deposition, they really have a wide range of what's relevant and what's not relevant to the claim in order for them to potentially find things that are relevant. So which means, although you may be like, what's my attorney who's supposed to be objecting not saying anything, is because we really are not supposed to be making that relevance argument unless it's very, very clear that it's not relevant. But mostly a lot of stuff is allowed in during the deposition. So be prepared to answer those questions and not wondering why anybody isn't objecting to it. Objection to form will be an objection you may potentially hear. That's to the form of the question. So how that question is being asked, is it understandable? And I'll show you some of the other ones. Compound questions are when they're asking more than one question in one question. They're asking two different things that are in one question. Asked and answered. If you've asked something, you've already answered it, you may hear an objection that talks about asked and answered. Because technically, if they've already asked you that question, here's what I'll tell you. Little cues are, if you've been asked a question already and you answered it, stick to that answer. They're asking it again because they want a different answer from you. When they ask you it again, you can say, just like I asked you before, just like I answered before, just like I said before. Because what they're looking for is for you to change it. And I always try to tell people, if you are not sure, say that. As far as I can recall, as much as I remember, it was 3 years ago, this is what I think. If you are not sure, that is an actual answer. It's okay for you to not be sure. Then for you to feel like you have to be forced into an answer, and then it will get used against you. The littlest things can get used against you. So I had a claim that had a big, huge contents, a demand on it. And they brought in the insureds, and the entire thing came down to a bedroom set that the insureds had on their list, and that they had said that they had purchased it at Lowe's. So they were like, oh, it was a bedroom set or something like that, and they purchased at some store. And this is why I always tell the insureds, do not lie about anything. If you're not sure, tell them you don't remember. There is no obligation to remember where you got all this stuff from. That wasn't a promise in your policy that you were going to keep all of the receipts. None of those things. But they get stressed out and they start feeling like they got to tell you where it came from and how much they paid for it then and all of those things, but they didn't really know. I was like, it's okay to not know. So during the deposition, she was asked several times about this bedroom set. And I was like, dude, okay, the bedroom set's like $1,500. Something's going on about this bedroom set. And so come to find out, what ended up happening was that bedroom set, literally like 6 years before, she had filed the claim for her mother. And she's the one who called it in, so they have great records. So they just searched her name through their whole database, and they went back to the recording. And part of her claim was for a bedroom set. It was the exact bedroom set. And so her mother had claimed it in the water loss. They had paid her for it. She gave it to the daughter, and then it got damaged in the daughter's claim years later. The problem is she had lied and said she had bought it from a store. That is enough to potentially ruin the entire claim. That's how detrimental it was. So had she just stuck with, I wasn't sure where I got it from, or I didn't really recall, I can't really remember where I got it from, she would have been fine. But after she had been first asked about, well, I don't really recall, I don't really remember, and then she had been asked again about, she's like, well, no, I do remember, I got it from, like, well, you sure you don't remember? Well, yeah, I got it from. Don't change your answer when you're asked again. And making sure that you're staying away from things that if you're not sure if it's exact, that you're letting them know that. And that is okay. That can be an answer too. Calls for speculation. Do not speculate to something you don't know. I know that there is a need a lot of times to try to, after you have been, their goal during the deposition sometimes is to discredit you, make you feel incompetent. So then you're trying to overcompensate it during the deposition by saying all these things that you know. And it's like, do not speculate to something that you do not know or you're not an expert in. Stay away from those things. Because you can be called out for one information that you're not an expert in that can now destroy your credibility for the entire other stuff that you were saying. So don't feel like you have to overcompensate, because that is a tactic of what they do also. They start asking you things that are not your expertise because you feel like you want to prove to them that you knew what you were doing this entire time. And then that's the kind of stuff that can potentially be used against you. There is Privileges. This is an attorney who would be potentially objecting to privileges. Not most of them always apply when we're dealing with contractors and PAs, but some of them are the spousal privilege, attorney-client privilege, the Fifth Amendment, and doctor-patient. Now, for you guys, the important thing to understand about the attorney-client privilege, I see this a lot, and this is one of those mistakes that I want to make sure everybody is aware of. The attorney-client privilege exists between the attorney and the client who is the insured. It does not exist between that attorney and the PA, or that attorney and the contractor. That privilege does not exist. So everything that you say to that attorney can be discoverable and potentially admissible. So you have to be really careful what you're putting in emails, what you're potentially putting in text messages to them, and what you're talking to them about. Because some of the very first questions that sometimes the attorney will ask you when you come in is, who did you talk to? How did you prepare for the deposition? And if you say, well, I talked to the attorney for the insured, what was the conversation about? And that's not protected. So you want to be really careful about that, because sometimes people will send emails to me asking me questions, and I'm like, remember, this is all potentially not protected information. So be really careful what you're sending into there. Fifth Amendment, most people know that, against self-incrimination. I've had instances, I've seen it before, where literally you may potentially have to invoke that on yourself if you feel like you're going down an area where unfortunately it may be used against you. So those are just some of those privileges. This is giving you an idea of what the factors that influence the outcome of a deposition. The very number one thing is the knowledge. How well do you know what you're testifying to? How prepared are you? Did you show up with all your information? What else people don't realize is that every time that you do a deposition, it can be used against you later on. So if you say something then, be prepared to back it up. Because if you don't, or if you're incorrect, and later on your position changes, that can be considered inconsistent, and you could be on the stand during a trial, and you could be cross-examined potentially, depending on what it is, with another deposition that you've already done. So take them seriously. When you're putting something onto record, it stays there forever and can be used against you at a later time. Then you have the expert credibility, which is what we were talking about. It's how credible you are, how consistent your information was. Did we see any inconsistencies? Even if it's not with what you were supposed to be an expert on, because you accidentally started saying something else, those things can be used against you. Okay, so any questions, answers? I think I did a decent time with my time. How much time do I have? Thank you. I'm notorious for going over, so he told me he was putting a clock right here that counts down. It says 2:07. I don't know how that's counting down for you, but it's an actual time. Okay, so the question that he had in regards to sometimes people are paid for their estimating writing based on a flat fee or based on a percentage. The answer when you're dealing with potentially trial litigation is this. When we talked about that credibility, this was in regards to the outcome of a deposition. Make no mistake, the outcome of a trial, if you're in trial, your credibility is number one. Most jury has no idea what you're talking about. They want to know if they believe you. That's how they're going to decide which side they believe. So one of the things that we do as attorneys to cross-examine someone's credibility who is an expert or is witness, but definitely an expert, is did they have a financial interest in the outcome of that number? Because arguably to a jury, it's what you're always trying to present something to from the very beginning, that's huge for them. If a jury's trying to figure out between two experts who wrote an estimate for damages and they find out one of the experts just got paid a flat fee to write it, no matter how large it is, and they found out the other expert is getting paid depending on how high the number is, that could come into question the credibility of it. And that comes down to when we talked about, when we talked about appraisals and the appraisers and stuff like that, and there are states that say, hey, if you are getting a percentage as the appraiser, it now makes it to where you're not biased anymore. You're not uninterested in it. You're interested in the outcome of it. You want to make sure that it ends up being higher, and potentially takes longer to settle because you're making more money the higher that it actually is. So yeah, so to answer that question, it absolutely does make a difference. It could come down to making a difference. It's just good to know that. I know there's business models where it has to be that way. We know that we've got the IA sides, that we've got insurance companies that are doing it, but it is grounds for a potential credibility argument of you have a vested interest in the outcome. How does it not affect what number that you are doing? The simple question we ask is, so that means, let me get this straight. So you'd agree that if it was $1 million and you were getting paid this percentage, you'd be getting $100,000, correct? Providing the estimate, yes. But if you wrote the estimate at $500,000, you'd only be getting $50,000, correct? Yes. Okay, so we'd agree that $1 million is more than $50,000, right? You know what I mean? So it's like those kind of things. So it's like it would potentially now call into question your credibility because you have a vested interest in the outcome of it. Absolutely. It's where we literally, it's one of my favorite areas to go in is how are they getting compensated, and explain to us what those guidelines look like, if there are any. So if sometimes we're able to find them in writing, if they've got balls enough to put them in writing. We have found a lot of them. But sometimes those guidelines are not really in writing. They're in internal emails that go back and forth. They're making sure they're not putting it somewhere that goes, hey guys, here's your manual to screw over insureds and not pay claims. They're usually a little bit smarter than that. But definitely asking them, how are they getting paid? How does that look like? Do you have bonus structures? Are you getting paid more every time you have a revision? That's a huge thing. Like every time you have to rewrite it, is there a fee for that? We've seen instances where they're getting paid because of the fact of they're in a certain bracket. Certain brackets are getting paid a certain amount for, when they write in a certain bracket, another certain bracket they're getting paid a certain amount for. So absolutely, it's definitely something that we ask and look into and figure out how much we can get of those guidelines, which is one of the hardest areas to get to, is to figure out who told you to engage in such egregious behavior. So documentation, we talk about a lot from the very beginning, because it also helps for your credibility as we're going to it. So when they're asking, if you're asked, what's the method of how you do this? You want to make sure you have intake forms, something you're writing all the information out when you first go out there and start doing that investigation. So those are the things they're going to be asking for. Who did you talk to? What have you relied upon? What are those reports? And you've got to have some type of documentation for that that shows, here's what we've done. A good timeline is great. Those are huge questions that they're going to ask you during the deposition. When did you first go out there? When did you do this? When did you do that? So as much of that as you have prepared, it all helps to make you seem more credible, to say, hey, no, I know what I'm doing and I did it accurately, and this is how I do it, and I don't leave any, stone unturned. So yeah, making sure you have an actual legitimate process of how you work a claim from beginning to end and how you document it from beginning to end. The more notes, cases are won and lost on those notes that the PA and the contractors have. I mean, I can't tell you enough about definitely looking at Insurance Busters and the PA boot camp and getting some of those files. Listen, get a file from Melanie Spoon and her crew, and you'll hear every single comment. You're like, and I called, and she was nasty to me, and this is what she said, and then they threatened to call the insurance commission on me, and all of those goodies. I'm like, writing a civil remedy notice for one of their claims is very easy to do. But what's really there is those notes are money. Money, money, money. That's where it comes from. It's the notes that you guys are doing, especially if a contractor is working a file, trying to help the insured and explaining the scope and doing everything in accordance with the law. You are usually getting really good notes from them. They're going to lie to you and say things that are not covered because they don't think you have the tools to respond, that they would never have the balls to tell an attorney. That's just the fact. I always say sometimes the arguments you guys are hearing are not the same ones that they try to tell us when we get involved. So your notes are crucial, because what happens when you're dealing with it all gets imputed onto the insurance company. So which means if we want to start holding them more accountable, if we want to be able to potentially go after bad faith, those kind of things, we only can do them really with the behavior that you guys are seeing and that you guys are documenting it. So when they're going over what is your process, what is your documenting process of every single step, and how have you investigated this claim in order to come to your opinions, conclusions, estimates, any of those kind of things. Yes. So I I pride ourselves in the fact that we are honest law firms. We're really serious about making sure we're only going after damage that is legitimate in nature. We believe that as a whole, we have an obligation to the insurance industry to make sure we're not the ones creating that problem. So I've worked with sometimes teams that have said to me, oh, well, I just send a bunch of teenagers onto roofs, and if there's any damage, they're gonna call you and you can figure out what the date of loss is. No. That's not how it works. So what I think one of the most crucial things is when you're first talking to these insureds are their testimony on what happened. And what do they believe is the damage, or at least what do they believe happened to this house? They may not know, obviously, the full scope of the damage. But if the information when you're sitting there for the deposition or when the insured sits for the deposition is, well, a PA or a roofer came to my house, they knocked on my door, they wanted to see damage, and then all of a sudden they said that I had an insurance claim. Oh, what's the date of loss? Oh, I don't know. So for me, what I really want to see is the insured's testimony to you that this is what happened. On this day, I had a hailstorm. On this day, the hurricane came through. They may not know that. They may even say, I didn't think I had any damage. That's okay. We can fix all that. That's fine. It's understandable. They're not an expert. They don't know. But it's about that cause of loss. What is it that they are saying has happened to their property that would have been the reason for that damage? That has to come from them. It can destroy an entire case if the testimony is, this is literally what I've seen some of the insured say. Oh, I didn't even know I had damage, but there's something called hail con, or there's something called, they're like quoting the apps that a contractor tried to pull up while they were in front of them. Hail trace maybe is the name of it. I think there was a hail trace, and he told me that it was a hailstorm that was in, what did he say, May 13th? He said May 13th. Horrible. It's horrible. And it's not that it doesn't make the claim legitimate, but it makes it a real issue for insureds to feel any type of way for them. So it really does give the insurance companies at least some sort of outgoing, hey, if there's enough here, let's take it to trial. Because a jury doesn't feel bad about someone who didn't even know they had damage, who somebody came to their house and told them they had damage. That doesn't breed any empathy. So what I'm always looking for is, what did the insured say about this cause of loss? Because that's what will come back to haunt you later on, is if they don't even know it all. And they may not know the date. You can be like, okay, well, they're like, well, I know there was a hailstorm, I don't remember what date it is. You can help figure out the date. You can use all of that stuff, but it's really, what are they gonna say about the cause of loss? Do they remember when it happened, and what do they believe took place? Yep. Okay, I've made my time. So thank you guys so much. I'll go back to the other page. Like I said, you guys, any questions you have, please, if most people know me, that you just reach out to me. My cell phone's up there, my email's up there. You can always ask our firms if you have any questions. That's what we're here for. We would rather help you and never, ever see a claim from you. There's enough claims that happen. You don't have to worry about that. We're all gonna be okay. We never are thinking, hey, you called me 20 times and you haven't sent me a claim. I am not that lawyer. You will not hear that from me where I'll say, listen, why aren't you sending me a thing? You're sending it to that lawyer, but you're asking me for advice. No, I wanna help each and every single one of you guys work through these claims, any questions you have, because we're working together against the insurance companies. So thank you guys so very much.
Thank you.